afternoon. Good afternoon. Welcome to the ADGM Arbitration Community Check-in. On behalf of ADGM and the ADGM Arbitration Centre, it's a pleasure to have you with us this afternoon. It's been a tough year. It's been difficult. It's been a struggle, but it hasn't been impossible. And thanks to the creativity, the innovation, the diligence, the persistence, the commitment, and the absolute desire to achieve above and beyond, the arbitration community, I think, has come out better than ever. The purpose of today is really to check in with you and to have a discussion with some of the most senior members of the arbitration community in the UAE. They've given generously of their time today, and I know they have anecdotes, examples, insights, and thoughts that we'll find extraordinarily helpful and perhaps reassuring because of the journey that you have also gone through this year. So we thank them very much for that. The arbitration community owes a lot to everybody who is participating and contributing in every way possible to ensure that the clients and the community as a whole stays together, continues to innovate, and continues really to come out from 2020, from this pandemic, from the challenges, better than ever. And I, here in the ADGM Arbitration Centre, we know that that's an absolute certainty. So without any further from me, it's my absolute pleasure to introduce you to our moderator, Lara Hamoud, arbitrator and senior legal counsel with ADNOC. This is Lara's idea, I must say, and I'm tremendously grateful to her for really promoting what is to check in with you and to get together again because we've been apart for so long. So on that note, Lara, thank you so much. We're really looking forward to this discussion.
Hello, everyone. Thank you so much, Linda, for this introduction, and a big thank to the ADGM for allowing this forum to take place. As you said, Linda, it's been a tough year, and it's tough not to be able to touch base with your peers. I think with the lockdown and the pandemic, we've lost touch, and this is an opportunity today during this live webcast to catch up and to share our views and experiences on how arbitration has evolved lately with the pandemic. What have been our main challenges as arbitration practitioners, and how have we been adjusting to these difficult times? What type of disputes have arisen during this crisis? How arbitral institutions have responded and are still doing so to the disruptions that we've all witnessed. These are questions that we would like to answer to with the panel who is with me, the speakers who are with me today. You will see very familiar faces for all being eminent arbitration practitioners and who accepted to share their views and experiences with transparency. I'm going to introduce first Dr. Habib Al-Mulla, who is a partner and executive chairman at Baker McKenzie. Habib Al-Mulla. Dr. Habib don't need an introduction. We have Alex Bevan with us, who is a partner in the international arbitration practice at Sherman & Sterling, based in Abu Dhabi. Alex has a beard now, I can see. We have Anne Hoffman, who's independent arbitrator of Hoffman Arbitration, who's based in Dubai. Adrian Cole, who also has a beard, now partner at King & Spalding, based in Abu Dhabi. And finally, Dr. Dania Faz, who you all know, who represents the ICC as a deputy director in the representative office in Abu Dhabi. I'd like to thank you all for being with us today. One thing about the audience, we can see you, and we can't see you, unfortunately. You can see us, and in fact, you're welcome in our respective homes. We can't see you, but we've seen a list of the participants. We saw that there were more than 140 and maybe more now, and we saw who's there. We would like to say hi to everyone and to thank you for participating and catching up with us. This is an event for all of us. We want you to ask questions. We will allocate some time at the end. And we really hope to have a broad sense of everyone's experience at the moment. That's really the purpose of this webcast. So without further ado, and to jump straight in the substance of the discussion, I would like to ask first, Alex, maybe, just to give us your personal experience, an example that you've witnessed, that you've lived during the pandemic, where you really felt that, or they can really reflect the impact of the pandemic on your practice and on the arbitration in general. What would you like to share with us?
Well, hi, Lara, and hi everyone else. I think we have two different phenomena. We had the initial reaction, and then we have how it's changed since then. I think initially, in spring, early spring, there was somewhat of a slowdown in our cases. And to be specific, for example, we had a major merits hearing scheduled for spring, which was deferred by the tribunal. The tribunal adopted essentially a wait and see attitude or approach to how things might develop, thinking that it might be temporary, as we all did, right? And so we saw procedural timetables pushed back, hearings pushed back. Again, expecting maybe that in the second half of the year, we might all reconvene, be in a position to reconvene and have in-person hearings. Obviously, 3-4 months into the pandemic, it became quite obvious that that wasn't going to happen. And so what we saw then was a transition to an adaptation, I think, to the prolonged travel restrictions and the prolonged social distancing. So tribunals have been exploring ways of being a little bit more creative in making progress with cases in order to avoid delay rather than just waiting. So we've had things like, we're now exploring with tribunals things like the bifurcation of cases, determining preliminary issues, having claims identified and pleaded and argued early so that they can be dealt with, even on the papers. So this is, like I say, still in a process of adaptation, which is very interesting. And different tribunals are obviously adapting to different paces and in different ways. So I think it's still a work in progress, Lara.
Yeah, I don't know if it's a good thing, Alex, but Adrian, we would like to share something that you've witnessed. One example related to your experience.
Yeah, thanks, Lara. Good morning, good afternoon, and probably good evening to people on this call. I agree with what Alex has just said. That there's been a change, but to some extent, one of the surprising features of COVID has been that the change hasn't been that extensive. The impact from COVID, from our perspective, my perspective, is that actually businesses managed to proceed as normal. By way of example, we had injunction proceedings in the English High Court, Technical and Construction Court, relating to some arbitrations, where we were seeking to injunct an expert from providing services to both sides of a party, or both sides of a dispute. That case goes to the Court of Appeal. What's happened? Well, first of all, that case was dealt with virtually. It was the first virtual hearing in the English courts. The appeal, which is set for later this month, was going to be done in person, but is now, with second lockdown in the UK, is being done virtually. So again, there's complete flexibility and adaptability in the processes. And we see that in arbitration in the way that Alex has just described. Tribunals have been very quick to recognise that they've got a duty to get on with the job. that they've still got an obligation to bring about the fair and expeditious resolution of disputes on a cost-effective basis. And that means putting in place measures to allow that to happen. So I think what we're going to see continually is an evolution rather than a revolution in the processes that we have.
Thank you, Adrian. Yes, so it's work in progress. It's an evolution rather than a revolution. It's adjustment and flexibility, adaptability from all stakeholders. No dramas. That's what I can understand so far. What about you, Dr. Habib? Anything you would like to share with us also on as a general experience?
Good afternoon, everyone. Thanks, Lara. I echo what Alex said. I mean, initially there was a kind of a shock and everything got stopped. But gradually, I think we managed to get over and things went back to normal. I think, however, that we have not seen the impact on the arbitration practice yet. I think the impact is going to come when things, the economy in particular, goes back to normal. At that point of time, we will see whether the number of cases are going to increase, whether there is a backlog that need to be cleared, whether people will resort more to litigation, or whether they resort to settlement. So I think in the next 4 to 6 months, I think we will see the impact.
Yeah, so it's a long-term or impact, and I agree with you, Dr. Habib. We would have a better idea at a later stage. But if we now try to kind of take a snapshot of the general impact of the pandemic on arbitration and have a general view on, let's say, the disputes, first of all. I know we would have a better idea at a later stage, but to date, how could you? So I know, or I hear from counsel that as a result of the pandemic, their practices, dispute resolution and international arbitration, are getting very busy, while their colleagues in transactional related activities are getting quiet. So I hear that counsel are being quite busy, and there have been an increase in the number of disputes as a result of the pandemic. And I would like to hear your views and your experience on that. Maybe Alex, you wanna respond to this first, and then we'll hear the others' views.
Yes, thanks, Laura. I mean, I think, so you have the usual course of disputes, the typical trend, if you like, which is obviously continued, and then you have an incremental, or I think what your question is getting at is, well, what's the incremental volume of types of disputes which are arising because of the current circumstances? And I think there we have to be quite nuanced, because I think initially, certainly you see an increase in the escalation of what we call default disputes, people not paying, payment defaults, a little bit of failing to proceed with transactions, failing to close on deals, and also sometimes, let's say, creative ways in which people are seeking to raise capital, which can then trigger claims under various existing financial arrangements and security arrangements. So certainly a spike of those sort of default-related type claims initially. However, not all of those lead to arbitration, and certainly not the kind of arbitration that we would typically come to my practice, which, so where you think about long-term joint venture or shareholder disputes, investment disputes, construction projects, the disputes themselves are likely to take longer to bubble up, right? There's a very significant lag or lead time between a catastrophic event like a shutdown and something going to arbitration. There are some exceptions where it happens very quickly, but on the whole, there's a lag, as you'd expect. So we're starting to see that surge, interestingly, now. And I'd certainly be interested to hear from the institutions at the end of this year whether there's been, particularly in the back end of the year, an increase in the number of registrations of requests for arbitration, because it's certainly, the surge is coming for sure.
Well, I think Dania would enlighten us on this, because even without waiting until the end of the year, we already have an idea of what happened. Dania, would you like to give us the ICC's experience when it comes to disputes?
Yes, absolutely, Lara. Thank you, and pleasure to be part of the discussion. Back to actually what was mentioned by Alex, in terms of the volume of filings that we have witnessed throughout this crisis, since the emergence of the pandemic, throughout the lockdown period and post-lockdown, to this day, if we look at the number of filings, we see that the filings at the ICC MENA office has not seen any drop in the number of filings. So we did this exercise in comparison with last year. From January through August, we had around 22 filings, while as for last year, 2019, we had for the entire year around 33 filings. So from the figures, we think we're heading even down the line for a higher number of filings. This actually confirms, if anything, that litigation is in good shape, which comes unsurprisingly, as we all know that in challenging economic times, rarely disputes are affected, while the other department, the corporate department, as you were mentioning, Lara, struggles more. In terms of industries featured in the filings, we know the predominance of the construction sector, the traditional sector in the region, disputes arising from the traditional types of agreements, whether we have building design and services, security construction services, purchase of pipeline equipment, and so on. Unsurprisingly, the pandemic has had an impact on the types of disputes that we see as a result of a shortage in cash flow and constraining financial conditions. So we see claims related mainly to outstanding fees, contractual payment default, as Alex was mentioning, repudiatory termination of contracts, delay in completion of work, call-on guarantee. These are the types of disputes that were featured in recent filings.
Thank you, Dania. I certainly see, in my experience, a lot of claims submitted in the construction industry, I would say, and a lot related to force majeure. And we don't want to go into that topic during this session, but I would like to hear from my colleagues if they confirm the increase in disputes and in claims. Maybe they haven't crystallized into arbitration yet, or they won't. But if they've seen this big volume of claims related to, and more in the construction industry. Adrian?
Yeah, I mean, we're seeing the type of claims that Alex mentioned, which is payment disputes, etc. My practice focuses very much on construction and engineering matters, both infrastructure and the energy industries. And it's typical in these industries for claims to have a very slow burn. So in my practice as arbitrator, I'm seeing a bunch of disputes which relate to the last financial crisis, the global financial crisis. So it just demonstrates how long it takes for things to come through. But having said that, we are seeing an increase in, for example, the use of emergency arbitrator proceedings, as parties are trying to either protect their position or take an early advantage. And that's one of the changes, I think, which COVID will bring about. It'll be interesting to hear from Dania and others as to how the institutions ultimately deal with these. I think that the opportunities, though, for all of this is that parties have a window of opportunity to sort out their cases before they bring them, before everything starts going a bit crazy. Because I think, as Dr. Habib mentioned, these claims will come on through. It's just a question of timing.
And if we focus on the users and the practitioners, do you believe that with this environment, users are more inclined to settle? Or to the contrary, they're being more aggressive and willing to go into arbitration. What would you say, Alex, on this?
I think with settlement, it's interesting. So I've noticed sort of two what I call countervailing considerations, or considerations that pull in different ways, right? The first is the proposition that cash is king, right? Parties want to cut their losses. They want to draw a line in the sand. They want to avoid escalation. They don't want to throw money at dispute, at formal dispute resolution, litigation, or arbitration. And the amount of times that I've been told in recent months by clients, look, we need to settle this. We need to settle this. Certainly that's driving a desire to settle, but the countervailing consideration is that what we're seeing is that the other side of the table is parties are exploiting the situation, particularly debtors, right? So debtors are thinking, well, I know I owe you money, I know you are hurting, but I'm going to use that leverage I have to string out and secure a discount on my debt, right? So you've got these different variables that are pointing in different directions. And so even though it might be counterintuitive in this sort of environment, I do think it's a debtor's market, in the sense that creditors have a weaker negotiating position and a greater willingness to compromise. The other consideration about settlement is that, at least when we're brought in to assist settlement, clients with a brokering a settlement, it can be very dependent on the personal dynamic, right? So getting in a room and negotiating a position, airing your views in a constructive way, negotiating, explaining your position, building up a degree of trust is very important to secure settlement. It's less easy done remotely. It's less easy done other than face-to-face. And that, what you see instead is an exchange of positions remotely by use of telephone calls and spreadsheets exchanged. And that's missing a vital ingredient, in my view, to get deals done and to get settlements done.
That's very interesting, Alex. So the personal touch would have an impact on the outcome of the settlement. Dr. Habib, do you have any opinion on that? To what extent, this is impacting the possibility to settle?
Yeah, every time the economy is in downturn, there is a trend for litigation and, arbitration, of course, to increase and for transaction to slow down. However, I think if we are comparing this to 2008, this is nothing at all compared to what happened in 2008, where disputes surged up, and to the extent that I think it's not going to be repeated, at least, hopefully in our lifetime. Yes, there has been an increase, but it has been kind of a steadily increase. The main problem that people are facing, I think, is the finance. So even if they are willing to go into an arbitration, the problem of financing is an issue. And I think, this is to some extent outside the scope of this discussion, this is a good opportunity for third-party funding, in fact, to come into play in this region. I think the doors are widely open for them now because there are large and multiple arbitration, but the parties are lacking the finance needed in order for them to proceed with it.
Right, and so to what extent, maybe Adrian, you feel in your experience that the fact that parties cannot meet, would affect the relationship, the settlement discussions, the negotiations? How have you seen any impact on your practice?
I think I've only seen limited impact, to be honest. I accept Alex's point, which is that it's much harder to communicate emotion virtually, whether it's through correspondence or whether it's through a Skype or a video con of some sort. I think it's much easier to bang a table and to be aggressive or emotional in a face-to-face meeting. And indeed, that environment has been put on hold. Whether that stops any settlements from taking place or not is a different matter, because I think people at the end of the day will be looking for facts and understanding and particulars in order to make a reasoned decision, whether you're the claimant or the respondent in a matter or their counsel. People are going to be looking at things to rely upon rather than pure emotion. So I think I think settlements can continue to take place. I don't see any reason why they shouldn't. I think sometimes emotion is a noise which gets in the way of settlement, and actually COVID and virtual hearings and virtual discussions may get rid of that noise.
Right, so maybe it's a positive thing. I'd be interested to hear from the audience also on the third-party funding. I hope we'll get some questions or comments on that, just to see what's the situation in the market at the moment. One question I would like to ask Anne is, what are the main challenges in your view, Anne, that arbitration practitioners have been facing with this crisis?
Well, I do think that one major issue, of course, is the need to adapt to technology very, very quickly and in lightning speed, in order to be able to progress cases, you know, with the use of documents, with the use of hearings, with remote in remote ways. Other issues, I think, have been, you know, evidence, i.e., how to progress a case, especially during the lockdown times, when, you know, documents might not have been accessible easily. So I had a case, for example, that, you know, the tribunal was asked for extension to submit to make a submission because the evidence was in a warehouse, and nobody had access to that warehouse because nobody could leave the house. So issues like that, and then, you know, of course, not so much for me because I act as an arbitrator, but counsel and people, i.e., you know, law firms working in teams. Of course, the need to be able to connect with your colleagues in this way. I think, you know, some law firms were more used to it than others in terms of people working from home, and you know, I think that is something which teams needed to get used to, and might have found it more or less difficult depending on, you know, how familiar they were with each other before. If you work across offices internationally, then that might have been something which was easy anyway, but if you were used to having your colleagues always next door, then that's something which might have been more difficult. Or, you know, someone who came new to a team, and how do you train people? How do you make sure that they become a proper part of the team when you actually hadn't seen them ever face to face before? So I think it's a whole variety of issues which you know, come into play.
I think we've all suffered from this, and we hear you very much. Yeah, Alex, do you want to add something on this particular question, your views on what were the main challenges that the practitioners have been facing?
Yeah, so I think I mean, it's a sort of picking up Anne's point and running with it. Anne acts predominantly as arbitrator, but as counsel, there are two closely related things that aren't happening anymore that used to happen, right? The first is being able to get out there and spend time with clients, and in particular, the strategizing, the standing up with a pen on the whiteboard, the arguing about how things should be done, that process, and the same with the team. You know, even without the client, just brainstorming, working through, wargaming different bits of strategy of a case. That's much less easy now. Now it's much more desktop based. Of course, we have this technology, which we all are now very adept at using. But the job is less fast paced. There's obviously no travel. You have more time to reflect. So I guess going to Adrian's point about settlement, maybe greater rationality and less emotion will lead to better case strategies as well. From my perspective, it's less fun, certainly less fun. It's taken that human element out of it, less of a whirlwind. And like I say, greater opportunity to reflect. But there's something that I think the team loses in terms of really unlocking the right strategy for a case when you can't get together.
Can we say that our job as counsel have changed?
I mean, my point on that, Lara, is we're all lawyers. You know, we've studied academic law. At the end of the day, this is a people services industry. We are providing services to people for what we've learned and what we can offer. It's an advisory job, and so I think the job has fundamentally changed in that respect, right? It's curious how we have to adapt to provide those people services without interacting directly with people so much. It's a very different. It's a different type of service that's being provided. So I do think the character of it is changing, and like I say, what we're losing in particular is the human piece of interacting with clients and with teams, and ultimately with tribunals, I think, although that's less important, or it's less noticeable. But there has been a significant shift, I think, in the dynamic of the client service. Yeah,
and no more whiteboards and writing on a whiteboard and strategizing together, and this may also, as you say, Alex, have an impact on the relationship and with the client. Dr. Habib, do you have any views on this about our job as as counsel? Has it?
Nothing more than what has been said. Personally, I have not seen much difference in the role that we as arbitration practitioners play. Yes, of course, there is more dependency now on technology in order to facilitate things. Whether this trend is going to continue or we are going to go back to our what I call usual style of working after the pandemic is over, that is yet to be seen.
We have someone from the audience, Michael Patchett, Joyce, on third-party funding. Dr. Habib is right. Third-party funding relies on effective enforcement. Enforcement in the Gulf is now much better, but the perception has not yet caught up. That's still a problem for third-party funding. That's one comment and view from the audience on third-party funding. Thank you very much. Moving now to national courts, and we're still taking a snapshot on the impact of the pandemic on arbitration, on the arbitration landscape. What can we say about the national courts? How did they react? What was the position as a supporting judge for arbitration? What have been your experiences with the national courts? And do you want to say a few words about it?
Yes, I mean, naturally acting as an arbitrator, I have a little less interaction with the local courts than some of my colleagues do. But of course, every now and then a case I have decided over, I've decided on jurisdiction, and before the national or the local courts, and there in such a case where I had rendered a decision on jurisdiction, which was then taken to the local courts, and where it should have been decided within 30 days according to the UAE law, it took 6 months. So the challenge was the challenge to my decision agreeing to jurisdiction was filed in mid-January, and the ultimate decision of the courts approving that decision was rendered at the beginning of July. So what it should have taken 30 days was much longer. And whilst I do not think that decision would have been made in 30 days in any event, because it should have been done then, by mid-February, when we didn't have a lockdown yet and things hadn't slowed down that much. I do think that the pandemic and the impact it had on all of us also had a serious delaying impact on some of the decisions the courts had to make.
Dr. Habib, what can you say about the national courts in this crisis?
My experience, of course, is mainly with mainland courts. So I'm talking about Dubai, not the ADGM or the DIFC.
Yes.
Initially, they went into full lockdown, and I was at the initial stage, and I was surprised. I mean, I was talking to them, why don't you go online? And they were saying that because of the load and the number of cases, it would be difficult. When the lockdown continued, I think they realized that they cannot continue like this. So they started opening, and they were having virtual hearings. From what I have heard from my colleagues is that these virtual hearings are going very well. I attended myself, in fact, one hearing at the Court of Cassation in Dubai, and I was surprised with how things went smooth. Everything ran fluently. I managed to do my pleadings. It was really smooth, and I think it's a direction for future. Criminal cases, of course, are still being conducted physically. I think for them, it's still difficult to have it virtual. So criminal cases are still going physically, and lawyers are attending the hearings, doing the pleadings in person.
Whether you're saying that the commercial and the civil cases and hearings are not physically conducted at the moment, they're all virtual?
Yes, they're all virtual.
And have you witnessed any delays in the decisions? No.
Not at all. In fact, things are going as usual.
So here again, we have a great adjustment, a great flexibility that took place. I would like to ask Dania about now the role of the institutions, and how have the institutions managed the challenges related to the pandemic? Just if you can give us examples. So we know that the ICC has issued in April, so very early on, the guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic. So we will talk about how institutions can help in the future at a later stage. But if you can tell us what has been the reaction, the position of the ICC as an arbitral institutions when the pandemic started?
Sure. Thank you, Lara. Early on, the ICC was responsive actually to ensure the continuity of the arbitration proceedings that were, as we all know, disrupted by the pandemic. The ICC issued its guidance note on measures to mitigate the effects of the pandemic. This ICC note actually provides guidance, best practices to the arbitrators and the counsel in conducting the arbitral proceedings. We must say that arbitrators have found themselves in a very unique situation under this pandemic, being not able to hold physical hearings due to the restrictions and the distancing, the travel restrictions, but also not having any visibility whatsoever on to when and to what date the hearing can be performed. So this was a unique situation, and hence the idea of the option of holding a virtual hearing became not only an option, but maybe sometimes a necessity to ensure the continuity of the proceedings. Other institutions have followed suit actually, and also have issued guidance notes. This demonstrates, if anything, the agility and the flexibility of the arbitration process, as we were discussing earlier. At times when, as Dr. Habib just mentioned, state courts were sometimes subject to total shutdown. This note provides some standards and some guidance for the arbitrator to ensure that the proceedings are not disrupted and to avoid any unwarranted delay. It also recalls actually the procedural tools available out there. And Alex earlier had mentioned some of these procedural tools like early determination, bifurcation, the possibility to rule on the submission of documents submitted, and not to maybe even schedule or set a hearing for evidentiary hearing to move forward. However, sometimes a hearing can be a necessity, and the objective of this note is to provide the arbitrators and the counsels with a roadmap and the best practices that should be followed to ensure the integrity of the process. So this is very important. The arbitrator has the duty, as per the ICC rules, to ensure that the resolution is fair and expeditious while preserving the due process. This is a duty, and this is an authority that the arbitrator has. And a classic scenario that can actually come up, one of the parties would object to holding virtual hearing. So the question would be, can the arbitrator actually move forward with the proceedings and set a virtual hearing? The answer provided by the note is yes. The arbitrator can move forward, can issue a procedural order, provided he or she provides the reasoning and set a virtual hearing, and this to avoid any unwarranted delay. To assist also the arbitrators and the counsels, one of the annexes is actually a checklist how to hold a virtual hearing, and this checklist actually is quite a helpful tool when you know that preparation is key. This is the shared feedback that we received from arbitrators who have successfully held a virtual hearing. We cannot underscore enough how preparation is important. Ensure that all the stakeholders have the right equipment, the right broadband technology. It's better for arbitrators to have 2 screens, not 1 screen, the camera, and to make the virtual setting as credible as a physical setting. Bearing in mind that there would be some challenges, as we mentioned earlier, but I would like you to give maybe a more positive note regarding virtual hearings. Some arbitrators actually have noted that in a virtual hearing, they were less swamped by documents. They seem to prefer electronic bundles to boxes, and they seem also to prefer having the counsel going straight forward. There are some upsides for virtual hearings that were noted during this lockdown. And I believe that it might have an enduring nature beyond the pandemic, but we all need to know that these virtual hearings are more suitable for not very heavy evidentiary cases and not very heavy document-intensive cases. The physical setup would still be a preferred option for evidence-intensive cases.
Thank you, Dania. That's very helpful. The guidance, the note, I think was really very practical and very helpful for the arbitration practitioners, in that it gave guidance in a situation where people or arbitration practitioners were a bit lost as to what they were supposed to be doing. And so I know from a personal experience that it was very, very helpful to see something coming from, a leading institution and to guide us internationally. About the virtual hearing, I know the note has a very detailed appendix on that. We can move to that now if we want to discuss now the impact of the pandemic more on the cases and the proceedings themselves. The procedural issues that we have faced, and what has been the new approach in management of these disputes. We can certainly emphasize and see the experience of the panel on the virtual hearings, but maybe before, more generally, what can you say about the procedural challenges that were triggered by the lockdown, the pandemic, more generally? And maybe, Anne, you want to start by answering this question from your experience as an arbitrator?
Well, challenges, we mentioned the urgent need to come to grips with technology. Otherwise, of course, requests for extension of deadlines on all fronts, deadlines for submissions, deadline for submission of documents, of course, asking for extensions or postponement of hearings, as Alex has already mentioned, with the tribunal then having to face for maybe one of the first times in their practice, and certainly in my practice at the time, is do we go forward with a virtual hearing, or any procedural rights potentially violated if we do? So those are the immediate challenges, I think have come up, and we have mentioned some of them already. what we do in the future, I think, is something we can then discuss at the end of the session, which I think is an interesting topic to look at.
Yeah, Alex, what can you say about procedural challenges due to the pandemic?
I think the most obvious one concerns merits hearings, right? And what's interesting, one of the questions actually by Sean Yates was, in what ways were people not ready for this? In what ways was arbitration not ready for this? What's interesting is that even those of us who've been doing this job for more than 2 decades, the idea of a fully remote evidence hearing is a first. First time I've done plenty of hearings where an individual has testified remotely by video conference, fine. But an entire merits hearing, it's a first. It's a first for almost everyone. So for a normal hearing in person, you tend to put in place a hearing protocol which will regulate the rules of engagement for the hearing. You know, things like time allocations, who's allowed in the room, what IT you can use, presentations, demonstratives, etc. But for remote hearings, it's very different. There is guidance out there. So if you take, for example, the SOL protocol that was launched last year, that deals with the taking of evidence, it envisages the taking of evidence remotely of a person, a witness or an expert, but in a live hearing. We're not going to do this year. Now, legal submissions are easy enough. Adrian's already discussed the court hearing that he did. I've done something that went to the English Supreme Court all remotely this year. Legal submissions are easy enough. But the taking of witness evidence, dealing with things like sequestration of witnesses, respecting PERDA, how to guarantee they're not looking at a whiteboard with some notes, how to guarantee they're not being fed something, that's something which we're all doing afresh. And so hopefully there'll be some leadership also from the institutions and other thought leadership in the industry about how this might be done effectively. But I think a lot of people are doing it, learning by doing, which is interesting.
Yeah, I think that's where we're standing at the moment, is that, as we said at the very earlier, is a work in progress and it's an adjustment. And I think we all rely as a professional, we all rely on each other's trust and understanding. And we kind of all in the same situation. And we're all learning, as you say, Alex, that's very important. Adrian or Dr. Habib, maybe, any procedural challenges that you've faced during this year?
Adrian, you can start.
Dr. Habib, you go first.
Okay. From my perspective, nothing, in fact. I mean, of course, arbitration takes time compared to sometimes even court proceedings. No challenges that I have seen relating to the current situation. I think this is going to come soon, and I like the point that Alex mentioned, particularly if witnesses are manipulated, expert witnesses, for example. I'm attending, I have 2, in fact, expert witness hearings. One is this month and one is next month. And I need to see how this is going to happen and whether it will go smoothly or not. And whether as an outcome of this, as a consequence of this, we are going to see challenges or not.
Yeah. That's where we were saying there's probably a new arbitration that will, a new type of arbitrating yeah. That's interesting question, Dr. Habib. Adrian, what's your views on this?
Yeah, I mean, I think it's the challenges that we have as practitioners, whether we're counsel as arbitrators. There's also the challenges to the processes that the tribunals are conducting. I mean, just dealing with the latter, I mean, there's an opportunity that COVID has presented to parties, of course, to be more obstructive to arbitral proceedings than they might have been otherwise. Parties, for example, have taken arguments such as, well, the rules do not permit electronic hearings or virtual hearings. And of course, then parties in the UAE turn to the provisions in the federal arbitration law, which allows for cases to be determined electronically. There's a point that Sean Yates has already made in his note about the forthcoming changes to the ICC rules to make it clearer that virtual hearings can be held. They always were allowed. It's just that it's now being made clearer. So really, the big challenge, I think, rests with the judiciary in whichever jurisdiction we're talking about, to take a robust approach to the challenges which may emerge, so that arbitration isn't challenged as a proper means of dispute resolution and spoilt by the tactics, the guerrilla tactics of parties who wish to derail the process.
I do think that the biggest fights I've seen, in preparation of hearings, for example, is the fight, and I underscore what Alex has said, for example, with regards to witnesses. So how is witness evidence going to be delivered? Where is the witness? Where does the witness have to be? Not on the sofa at home. How do we make sure that documents are not annotated? How do we make sure there's a good grasp of the room around the witness to make sure that the witness isn't being whispered to by someone else? And so I do think it is essential for both counsel and arbitrators that those kind of things are actually spelled out much more than they used to be. And we come back to the hearing protocols which have been put in place by institutions, or guidelines which have been given, that those are, people are familiar with that, and arbitrators are familiar with that. I have had hearings or cases where, two other arbitrators looked at me and said, oh, so what do we do? How do we, because the parties were fighting over those issues. Because I said, well, I do think there's a certain provision, or some provisions, which we should make sure are in the procedural order which we're going to issue in preparation of the hearing. And I think those are the kind of type of fine-tunings, apart from being generally technology apt these days, that parties, but also very much arbitrators, will have to deal with in the future.
If I could just pick up on that, Anne, I think I agree entirely with you, and without doubt, we as arbitrators or as counsel have to be very much more organised than we were ever before. And there are the challenges, as you describe, about witnesses giving evidence. But I think there's also some plus points as well. People have talked about the ability to read a witness. Well, I find actually virtually, when you've got a camera that's trained on the witness, it's much easier to follow what they're saying and detect their reactions to cross-examination questions than one might have done so when they're set some way away from the tribunal, behind the desk and often behind the bundles. And the other sort of positive which comes out of this is that because it's necessary for only one person to speak at a time, and that rule isn't always respected during cross-examination by counsel or by the witness, but the transcript becomes so much better. So there's less dots where words should have been in transcripts. There are actually some useful text now, and that's, I think, a considerable improvement.
Go ahead, Dania, please.
Yes, just to pick up on Andre's point, actually technology has attained a degree of sophistication which is really can help address many of these issues. The 360 camera that can make sure there's no one coaching the witness in the same room. Technology can help. We just need to have arbitrators that are savvy, counsels also that are familiar with the technology. But I think this is something that we will be seeing down the line. There have been advantages to virtual hearings that were perceived by users in terms of cost and efficiency. So I think it should be sometimes maybe a good avenue, provided the integrity of the process is preserved.
Yes, absolutely, Dania. So now it's a new criteria.
1 second here. I think that this is a very interesting point that Adrian mentioned, how to be able to see if a witness is being guided or not. The question which I want to ask here, in fact, do you think that we will need some kind of training for arbitrators to master this technique or not?
Yeah, that's what I was going to ask. Actually, it's a spot on. If it's a new criteria now to appoint an arbitrator for her or for him to be technically savvy, then I would say we all should take, trainings for that. But it is interesting. We're touching upon an interesting point, and that's the evolution we were saying earlier of arbitration. The hearing is one important milestone in an arbitration proceedings. And today it's conducted in a completely different way. And we know the impact of a hearing on a case. And so, yes, I think there must be preparation. There must be everyone involved in this being able to cope, I think, with this new trend. And whether it's by training or getting used to it, I think we're all learning again. Any reaction to this about the training? Or
maybe it can be on institutions.
Yeah, something for the institution.
I do think it is useful, and I agree with Dania. If institutions were to pick that up and do that as they have done with other challenges, i.e. training of arbitrators or practitioners how to write awards, things which the ICC I know that does very well. Of course that would be, I think, very, very helpful, and for all of us who are already in it at this point. I think to some extent the last few months have been learning by doing, and leaning on colleagues who have had the first experience to say, okay, how do you draft this procedure order? Making sure that all these aspects are covered, from learning from your last hearing, making sure, thinking, oh, that point I should have mentioned. And make sure I'll do that next time, because I realize it's important. And so I do think so. And I think, being technically savvy and sound and being able to conduct hearings like this will be one of the criteria parties will look to in the future, when they appoint an arbitrator. I mean, if you know that some 75-year-old arbitrator already had difficulty operating a normal computer, and write emails, him or herself, then you might have second thoughts about, do I want this person now to be my arbitrator, to be the chair in a case where I know there will be a virtual hearing taking place at some point down the line. So I do think it will become one of those points of parties considering when to appoint tribunals.
And by way of update, and actually the ICC will be as of next year having its own full-fledged ICC platform. So we expect that will be assisting the arbitrators in their journey, because it would be a virtual journey.
Right.
Yeah, it will be. I'd like to hear the audience views on their experience on virtual hearings, and thoughts about it. In the meantime, I would like to ask, we talked about new trends, and that's the one we were just mentioning, about the virtuality of arbitration. What else have you seen in terms of new trends? So how, we're talking about evolution of arbitration, or conduct by counsel when you're acting as arbitrator, any abuse, any specific conduct with a reference to the pandemic. What have you, have there been, you said earlier, Adrian, an increase of emergency arbitrators? So maybe you can just give your views, Adrian, on the new trends. What have been more kind of noticed lately in terms of parties' conduct as an arbitrator, or as an arbitrator, or even as a counsel? What have you seen?
Well, I think one of the big standout features for me is the ability of counsel of all sorts to be organised. As we're all discussing, COVID and virtual hearings require a higher level of organisation. And counsel, which has got control of the document management system, is able to present its case in a clear, cogent way, is also going to be more effective than one who is not. We're seeing some cases. I've got a case which I rather inherited late in the day, and the core bundle that was presented was a bit of a mess. And to try and navigate one's way through it is hard work. And council had to admit that there was no easy way of navigating one's way through it. It meant going into a long list of files, identifying a particular file, then clicking on it, and then searching for the particular document within that file. And there was no easy way of doing that. Contrast that with bundles which are hyperlinked. You can click onto a link and go straight to the document. It makes an enormous amount of difference. So good organization on a most basic level is fundamental. And just as a sort of closing comment, for those of us that work from multiple screens, I was reading yesterday, and I have no interest in this case at all, well, no interest in financial interest in this yet anyway. Lenovo apparently have produced a computer which allows the cursor to move to where your eye is. So if you've got three screens, you can literally look at the particular screen you're wanting to look at, and it'll move your cursor there. So if you're wanting to highlight some text on the transcript and then pop across back to where your notes are, or pop across to the document which is in the bundle, then that's technology which is going to make our future much more easier to handle. So
this is good news, everyone. Provided you get used to it. So at the beginning, you would need to close your eyes and making sure that the cursor is not going everywhere. But it's good news. Well, hopefully, yes.
But it's certainly a test for Tribunal to stay awake. Anyway, that's for sure.
Yes, absolutely. Have you seen maybe Anne or Dr. Habib or Alex, parties using the pandemic to get extension of times, and have you seen delays due to that, and how have you been reacting to any abuse in that regard?
I mean, I've certainly seen, the pandemic being quoted, shall I say, rather than immediately saying abused, to get extensions. In some cases, I do think justified. So this point I mentioned in the beginning about the access to documents, in order to substantiate a submission when there was a lockdown in Dubai and the documents were not reachable at that point. We did think there was an extension justified initially, but we also said as a tribunal that if this lockdown continues, you will be permitted to make your submission with initial scarce evidence, and then you can provide further evidence later. So from my experience, there hasn't been much uptake, or shall I say, much listening to these arguments, in the sense that they would have been allowed to postpone and delay proceedings. So, one clear case of asking for an extension or postponement of the hearing, which initially was planned, of course, to take place in person, and then the respondent said, would like to postpone this for 6 months, because we do think this is really important that everybody meets in person, when in fact this is a hearing with very limited witness evidence, and the tribunal said, no, we'll look at this for a while. But if it turns out that we will not be able to hold the hearing in person because tribunal members had to fly in, etc., then we will hold this hearing virtually, because we do not think that what's at stake here, and in terms of the amount in dispute, but also in terms of the evidence presented, because we touched upon the fact already that maybe from a certain point on, evidence might be very voluminous and might be difficult to manage virtually. But this wasn't the case like that, we decided, and therefore we said, no, this will go ahead as planned, and this will be virtual. So I do think, at least from my point of view, while the pandemic has been used as an argument to delay and postpone, at least from where I'm standing, it hasn't worked very well.
Yeah. Yeah, it is. I think it's also for the role of the arbitrator to step in and to make sure that there's no abuse and to take the decision necessary to conduct the proceedings in an efficient and
that was
quick
our
manner.
argument, and that was my argument also, to say, overall there is a duty of the arbitrator and the tribunal to make sure that these proceedings are still being conducted in an efficient way. And so while there might be on occasion, a balancing exercise, it shouldn't be allowed to be derailed.
Yes.
So
Alex,
Laura,
you want? Yeah.
Well, I was just going to say on that point of the constructive impact on arbitration, if you like, of the current circumstances. And this is not a trend yet, but we're seeing signs of green shoots, right? Which is a greater efficiency brought about by breaking up arbitrations structurally. So, we're used to bifurcation along the lines of jurisdiction and merits, or merits and quantum. And in a regular arbitration, there's a logic to leaving all merits here, to the end, to a single hearing where it can all be decided in one go. But where you don't have in-person hearings, I think that logic does start to erode.
Yeah.
I think if you're going to have a 2 or 3 week merits hearing, is it really feasible or desirable for arbitrators, for everyone else to sit around staring at a screen for 3 weeks? I don't think so. So what we're starting to see, and I really hope is going to be a longer lasting change in arbitration, is the greater willingness, particularly by arbitrators, because it's often not so much one of the parties, to break down cases into manageable bite-sized chunks, right? So identifying preliminary issues, whether they're factual, whether they're legal, or even individual claims, part of the case, which can be argued, decided, and an award issued in turn. So you have a series of partial awards. And I do think this environment, online environment, lends itself to that. I think it makes the case more manageable, makes it more efficient. And it's also useful because tribunals, firstly, it's more manageable for them, but also they can start, through the issuing of their partial awards, giving indications about their attitudes to certain cross-cutting issues. So it's actually helpful to parties. It does have the additional benefit, of course, of taking off the table, or at least partly taking off the table, the problem of arbitrator availability and counsel availability in arbitration, which is one of the single biggest causes of the length of the procedural calendar. Is everyone opens their diaries, when can I fit a 3 week hearing in? Well, if you're fitting in 2 days here, 3 days there, over the course of 6 months, it's a very different proposition. So I'm hoping that we see that.
Yeah, that's something that is also, I think, encouraged to the extent possible in the ICC guidance, is to have several partial awards, or look at the case, in different phases of bifurcation, rather than leave everything to the end. And that certainly would be very helpful. What about cost, Alex? Would that render the proceedings more costly?
Well, it shouldn't. I think the single biggest cost in arbitration, particularly large scale and in particular construction arbitrations, which tend to be fact heavy, technical, expert heavy, is the hearing. It's the hearing itself. That's the only time where you have, up to 30 people in a single room working full days. And I think if you can have a more efficient identification of issues and decisions on issues progressively, and if that's done intelligently and thoughtfully, then what it can do is lead to very significant reduction in ultimate hearing time, and therefore very significant reduction in cost, particularly where there are threshold issues. So the classic thing that comes up is limitation, notification, time bar, those sorts of things. There is absolutely no reason why those sort of matters need to be left until the merits hearing, and here alongside you hear the merits of the claim as well, if the tribunal has ultimately got a good chance of finding that the claim is time barred, or that it's waived because no proper notification was given, or some other basis, right? So I do think there's a very significant cost advantage of this being done, as long as it's done efficiently and intelligently, right? Not strategically, It's always strategically in the interest of one party to argue one set of issues be determined early. But if tribunals engage with those proposals, those procedural proposals early, and look out for the issues themselves, I think they can actually add more value and reduce cost overall.
Yeah, and your reaction to Alex's views?
I mean, I do think that, while a 3-week hearing might be now chopped up by doing this, and I do think this is something arbitrators should have done before this pandemic, i.e., looking at issues which could have been decided up front and managing proceedings this way. And I know that various famous arbitrators, Kaplan, Lucy Reed, etc., have made proposals in this regard. But I'm also hoping that this point of having to focus and having to condense points, and having to maybe no longer make submissions of 300 pages and no longer opening statements of 2 hours. All those points will generally lead to a hearing, to a reduction in hearing time, because there's only, and we'll probably come to this more in detail, but there's only so much time you can spend on a screen, and there's almost only so much time you can focus on a hearing when it's conducted virtually. So while I do think this is a great opportunity for arbitration in terms of being more flexible, whether you want to do a hearing in person, when we talk in a year from now, or whether you want to do virtual. If you do virtual, I do think you need to adjust and adapt to that, in the sense that no arbitrator is going to be able to follow a hearing as he or she might have done for 6 or 7 hours in person, to do the same on a virtual platform. I do think that the virtual means that you will also have a reduction in attention span and screen time, which people will have to face. And so I hope that all of this will be leading to more efficiency generally in how you conduct a case.
Yeah, maybe that's a good transition to speak about the future, because maybe that's what will happen in terms of positive outcome, which is, we've been criticizing arbitration because it's getting lengthy, costly, lacking efficiency, and maybe now naturally and inevitably everyone will have to go straight to the point, to have shorter pleadings, to have shorter hearings, shorter examinations of witnesses, etc., etc. So maybe that will be the new trend of arbitration, which is to adjust to proceedings that are balanced, as opposed to going too much into the what we were criticizing arbitration for, the length and the cost. Any reaction to that about how do you think arbitration will be evolving? And I would like to have any reaction from the audience on this. So Dania, how do you see arbitration evolving in the future, and what can institutions do to help arbitration develop and adjust to the new environment?
Well, if we look at the dispute resolution landscape, it doesn't seem to have undergone revolutionary changes. We don't seem to see a significant change in the user's approach to dispute resolution services, mainly to arbitration in general. However, and this being said with caution, it is still too early, as it was stated earlier, to draw conclusions. The cases that were filed over the past months are still in their early stage, for some in the reconstitution phase. So we might be seeing down the line amicable settlements entered into. It is true that parties are being very cost sensitive in the light of the economic recession prospects. There will be this sensitivity to cost and to find a way to reduce and have a very efficient resolution for their dispute. So they might be prompted to settle. This is something that we need to be observing down the line. We expect users to turn more to non-adjudicative mechanisms of resolution of disputes. We think of mediation, expertise, both disputes. I think users will be considering these avenues more seriously and beyond just ticking the box exercise, as it is sometimes a practice, just ticking the box of mediation before going to litigation. So we might expect such change in the approach of users to dispute resolution. From the arbitral institutions perspective, I think institutions would be considering how to cater for the new types of disputes that might arise medium and long term. In light again of the economic recession prospects, we think we will be seeing more insolvency claims coming out. Insolvency claims would be expected across economic sectors, including energy, also among financial institutions. We might expect insolvencies also in China's Red Index projects. We know that UAE was heavily involved, and we have more than 4,000 Chinese companies operating in UAE. We might expect also disputes related to the increased use of technology. We think of online retailing related disputes, B2B, B2C, e-commerce, disputes related to the use of data. And again, this actually brings to mind the confidentiality issue that was raised also for the holding of virtual hearings. And this is something that was addressed by some platforms to have an encryption that gives assurance to the parties that there is confidentiality regarding the exchange data and pleadings and evidence. So yes, we're seeing new types of disputes emerging. We're seeing also consumer claims disputes that might also come up. And these areas, cross-border insolvencies or consumer claims, are not traditionally captured by arbitration. For consumer claims, we see the predominance of class actions usually. Insolvency, there is a tension between cross-border insolvency and arbitration that was not really sorted out. So yes, I think that institutions would be considering how to cater for these new types of disputes emerging. And on the procedural front, we would be really considering the cost sensitiveness issue. And one timely amendment that was just is expected to be released in the new rules is the increase of the threshold for the expedited procedure application from 2 million to 3 million. So this comes actually, and I see it as a timely amendment during these challenging times where companies will be very tight on their legal budget.
Yeah, that's a very good point, Dania. Absolutely. Any reaction on what Dania said about the prospect and about the type of dispute that we will be seeing, or just arbitration in general?
I mean, Lara, I think, if I may, from my perspective, hopefully the days of sort of the colossal waste associated with travel at the drop of a hat, paper production of bundles, etc., hopefully they are largely gone. I had a big Middle Eastern case which was seated in London, which is still running now, but for a long time the tribunal was requesting a CMC in person every month for more than 2 years, virtually 2 years, in spite of our protestations, in spite of the fact that everybody needed to fly in other than the tribunal members. I'm hoping those days are gone. My concern, though, particularly if you see the reaction to the Pfizer announcement of their breakthrough, which is obviously great, my concern is that we have a bit of a roaring 20s reaction, which was the reaction everyone had after World War I and the Spanish flu, which is everybody is so determined to get back to how things were and to go, swing back into action, that they violently default back into the inefficiencies that we had before. I'm hopeful that's not going to happen. I'm relatively optimistic about these things. I think it's for all of us to make sure that the process is leaner, more fit for purpose, and of greater value to our clients than it was in the past.
From what we've been discussing today, I think we're all very optimistic, and I think we're all looking at, despite the situation, the future of arbitration positively and with optimism. So that's good, and maybe it's a good transition to ask my last question to the panel about us, the arbitration community. We had this check-in today to catch up, to be together, to share views. Unfortunately, we cannot have the live views of our colleagues sitting in their homes. But but we shared ours with them. We had a few questions, but then I would like to ask you, what can be done for the arbitration community to network, to get together, to share views, to market itself? That's about the future. Anne, do you have a view on this?
Well, of course, I mean, I do think everybody, and we all said this preparing for this panel, we're all, hoping and waiting for the time when we can all go and have dinner together as a bigger group. I mean, it happened in Dubai every now and then, but largely, of course, we're limited to this kind of networking. I have experienced generally very good networking on certain, platforms and events. GAR or Dubai Arbitration Week happens next week. GAR is very much involved in this. I've been part of this, and I have to say, for example, what I've seen there was whether I like it or not, in the sense of, is it the same as meeting my colleagues in reality and non-virtual reality? Is it the same? It is not. But does it offer good opportunities in the meantime? I do think it does, and I do think events like this one, checking in, discussing what's happening, meeting, or having a coffee with one colleague at a time, for example, which is possible, it still helps. And I do think, maybe for the bright new world we're now in, this will be something which stays. Having conferences and having these kind of events, both non-virtual and virtual, a hybrid, at the same time, so that people can access, because despite all of its limitations, I do think there's advantages about what happens now, in terms of access. So I'm able to access, any conference around the globe if I'm willing to get up at 4 a.m. in some occasions, but it makes my life easier. I can choose, and hopefully, or will be able to choose in the future, do I want to travel in person somewhere, or do I want to, participate virtually? And so I do think there is opportunities, and this current situation has not just limited us, it has also, on the other hand, sort of broadened our horizons, in the sense that, we have gained access to some events which we might otherwise not have access to.
Yeah, so a positive note from Anne. Here's Alex again. Any other views on Dania? Any views on how to network in the current environment, and how do you see networking will take place in the future?
Well, obviously, if anything we can notice now is the lack of predictability on all fronts. So we're just, following the developments with this pandemic. We just hope that the restrictions will not be long-lasting, and that a physical forum will be available again for all of us. I still believe, and I think this relates to what we discussed previously with Alex, when he shared that he was cynical with respect to virtual networking. I believe so. I believe that it can be a good transition, but hopefully it will not be the new normal. I hope we will be back to physical forums and of the old days, while being cost efficient.
Yeah. So as at least now we have the option, right? We can do both. If we can't travel and we don't want to spend the cost for traveling, at least we can work with anyone anywhere, or network with anyone anywhere. But I do agree, personal, networking is kind of, I think that's what we're all missing at the moment. I don't see any questions from the audience, and I think the few comments that were shared were dealt with by the panel. I think it's time to wrap up and thank the panelists for their very genuine and transparent answers and views. Thank you all for sharing your experience. It's great seeing you. It's great. It was great having this check-in with the community. I think Linda will say a few closing remarks. So I'm going to say bye to everyone, And thanks again. I hope you enjoyed this session and hope to see you all soon. Thank you very much.
Thank you, Laura.
Laura, thank you. Thank you very much. And on behalf of ADGM and the Arbitration Centre, Adrian and Dr. Habib Dalia, Alex, thank you so much for your time. I think everybody would agree that you dealt with an extraordinary range of topics in a fantastic way, which was to provide your insights and anecdotes. And I think that it's unusual to be able to tap in to the minds of such senior, experienced people who have lived through this and come through the pandemic with, you know, the extraordinary resilience that you have and that you've been steering your clients through. So really amazing. Thank you so much for your time. Laura, Cyril, thank you so much. Brilliant idea, as you can see, with so many people participating. We had a few technical issues at the start, for which I apologize, but everybody eventually joined in. And I think brilliant moderation. Thank you for really taking everybody through those topics. If I could end on one note, which was the final if you like, topic that we dealt with on networking, which is to give to the arbitration community, ADGM and the Arbitration Centre, absolute commitment to provide as many opportunities as we can to enable you to network, to enable you to get together. I hope physically, not before too long, whilst we may not do the roaring 20s that Alex suggests and go back to those days. But whatever we can do to support you so that you keep connect with us and that we can facilitate the discussions, the continuing discussion, and the brand new frontier that we're all now meeting, really, and I feel like going through together, then that is an absolute commitment from us. So on that note, again, to all of you and to our audience, many thanks. We really appreciate it, and we look forward to keeping on with the discussion and so much more to come next year. So all the best, very best to you. Keep safe, keep well, and we look forward to speaking with you and seeing you soon. Thank you.
Thank you.
Many thanks, Linda. Are we back?